And it is my great pleasure today to introduce the inaugural professorial lecture of my colleague, Cormac. Inaugural lectures are always very special occasions, and they always draw a very special type of audience. A mixture of colleagues, and also of friends and family from near and from far. I've had the pleasure of having got to know various members of Cormac's family over the years, or at least I've met some of them. And I wanted to extend a special welcome to them all tonight, to the Irish contingent, to the Danish contingent, and also to the Scottish contingent, if anyone actually self-identifies Scottish. It's always a delight to introduce a colleague's inaugural lecture, but this is a special privilege for me today. Once upon a time, a long time ago, in the glorious hills of Tuscany, Cormac was my PhD student. It has been quite an experience to see his transformation from callow youth to the cosmopolitan sophisticate we see today. Seriously though, while he has achieved a lot, he hasn't changed that much, and he has retained all of his good qualities. A keen and sharp intelligence, a genuine intellectual curiosity and ambition, a social ease, not always, but most of the time, a genuine intellectual curiosity, as I said, an innate kindness, and very important in these trying global and institutional times, a good sense of humour. Perhaps that's the most important thing of all. He is by no means the first of my students to be elevated to the rank of professor, but he is the first to have done so in my own institution, and I take a special pride and satisfaction in that. All the more so as I count him as a close friend, as well as an intellectual soulmate. Cormac has pleaded with me not to go on too long about his achievements when introducing him. I rarely do what he says, but since it is his day today, on this occasion I will. Let me just point out a couple of things. Having been educated in Belfast, Dublin, and at the European University Institute in Florence, Cormac arrived at Edinburgh Law School as a lecturer in 2008. He was promoted to senior lecturer in 2016, and then to his present position as Professor of Public Law in 2022. Mirroring that impressive rise, Cormac has built up a remarkable body of work over the past decade and a half. He has over 38 publications in peer-reviewed journals and collections, including such prestigious outlets as the Oxford Journal of Legal Studies and the International Journal of Constitutional Law. He is also the author of many shorter pieces and blogs, often commenting on the key constitutional questions of the day. Probably his standout publication, and the one that has done most to cement his international reputation, however, is his 2022 OUP monograph, Constitutional Horizons, Towards a Pluralist Constitutional Theory. Here we see, to full and impressive effect, his trademark sophisticated grasp of the intricacies and fragilities of constitutional thought in an age of ever more closely interacting domestic and international legal systems. Over the last few years, his attention has turned increasingly from normative pluralism as it manifests itself between legal and political orders, which was at the core of his 2022 monograph, to pluralism and disagreement within legal and political orders, and on the threat to that pluralism, which is posed by populism and other forms of intellectual and cultural dogmatism. And it is this newly extended set of questions, I believe, that lie at the heart of tonight's talk, to which I'm very much looking forward. Without further ado, therefore, let me pass the floor to Cormac to deliver his inaugural lecture entitled Holding the Centre, Politics, Pluralism and Public Law.
So the title of my lecture is Holding the Centre, Politics, Pluralism and Public Law. It is a cliche that we're living in interesting times. Politics over the past decade and a half has unsettled much of how we understand the world. We can trace this, I think, to the financial crisis of 2008, but you'll have your own story about how we got to where we are today. One thing we've seen in this period is the rise of what's often called populism in politics. Now, I have to comment on this slide. So You may have noticed that some of my previous slides and some of the subsequent slides were quite artfully arranged and text and photos nicely displayed. For those of you who work with PowerPoint, this is because of the designer function that I'm sure many of you know. You dump your content on the slide, press this button, and it arranges it very nicely. But when I did it with this slide, PowerPoint would not play ball. It just said, no, I'm not doing it, I'm not going ahead, I'm not going to arrange this material. So either I've put too many photos in this slide, or PowerPoint doesn't like populist politicians. So I'll leave you to draw your own conclusions as to what happened there. And this phenomenon of political populism provides another context in which to explore the theme of pluralism and holding the centre, which has been of the central interest of my research. In particular, in this lecture, I want to explore the harm in populism. And given my interests of pluralism and holding the centre, I want to use the idea of political pluralism as a lens to explore this harm. But to do this, we need to do two things. Firstly, we need some sort of benchmark for assessing harm, and we also must clarify what we mean by populism. So my benchmark for exploring harm is the very idea of public law. And by public law here, I mean a norm-based practice which is attached to governing, whose core function is to legitimate governing. And it does this by promoting particular values. Which values are these? Well, we could all probably come up with our list, but here are a few. Liberty, equality, the rule of law, accountability, the separation of powers, fundamental rights protections, and democracy and political pluralism. You may have your own list, but the main idea here is that public law is about values and promoting those values, and this constellation of values that I have in mind here. So the harm then would be anything which challenges or undermines or attacks these public law values. My second question is, what is populism? Now, as many of those of you who work in the field will know, there are many versions of answers to this question. In fact, there's an entire academic industry dedicated to defining and contesting definitions of populism. I don't want to engage with that literature here. Rather, given my interest in pluralism, there are three features of populism that I think are relevant to this theme. And these three features, I think, about which is a reasonable consensus in the literature. So what is populism? Populism, first of all, is anti-pluralist. Secondly, populists see our societies as fundamentally divided. And third, populists tend to be non-revolutionary. We'll take each of these, starting with the last, non-revolutionary. Populists do not gain power, as is often noted, in the classic authoritarian ways. They don't engage in a coup d'etat, a military overthrow of the government, installing a council of generals. Nor do they engage in false flag emergencies leading to Nazi-styling and enabling acts, like we've seen on the Weimar Republic and the rise of Hitler. Populists of the type we're seeing today and that have appeared on my slide generally rely on democratic legitimacy. They play the democratic game. They contest elections to get into government, and they trade on their legitimacy, a democratic legitimacy, while they're in government. That's not to say that they haven't flirted with revolution. We all recall the events of January 6th of 2021 in Washington, D.C. with the storming of the Capitol, or the events in January 8th and the attacks in the Brazilian Congress in 2023. But these have been thankfully exceptional cases. Secondly, populists are focused on division. For the populist, our societies are fundamentally riven. They're fundamentally divided between a pure people and a corrupt elite and their supporters, as is often referenced in the literature. For populists, Yeats's gyre is very wide indeed. Thirdly, populists are anti-pluralist. That is, that there is one will, that of the pure people. And there's no dissent, no pluralism within this will. The will of the pure people is the only will that counts in politics for the populist. And populists claim a unique ability to determine who the people are and what their will is. So where's the harm in all of this? Well, in the context of pluralism and holding the centre, it is the anti-pluralist element of populism which is the most obvious place to start in terms of identifying the harms of populism from the perspective of public law and its values. And this is something that has been emphasized by some of the main thinkers in the field, such as Jan Werner Muller here on the left from Princeton University, and William Galston, who I think works for the Brookings Institution in the US. And they both have emphasized this idea that the main harm in populism is this idea of anti-pluralism. Recall, this idea is that populists do not brook dissent from their claims to represent the pure people. The will of the pure people is simple and it's clear. Those who disagree are othered as belonging to the corrupt elite or their supporters. And this is particularly clear in populist denigrations of the media. And we've seen this on many occasions where a journalist questions or challenges a populist, and rather than engage, the populist just dismisses the question as badly motivated. And this idea of the MSN that has entered in US political discourse, the mainstream media, which can't be trusted because they're part of the corrupt elite. But why does all of this matter? Why does anti-pluralism matter? Well, to understand this, we need to delve a little deeper into this idea of political pluralism as a value. What is it? What is its value? The first thing to say is that it's clear that pluralism is a key value of public law. It is closely linked to disagreement, to democracy, and to fundamental rights, such as the freedom of expression. I have, I'm delighted to say, a local and old reference from the Claim of Right for Scotland from 1689, which I have read in its entirety, and apart from a obsession with papists, it does also have this interesting line, which is that the freedom of speech and debate will be secured for parliamentarians. So we see here, back in the 17th century, the idea that people should be able to disagree and have a freedom to voice their disagreement and debate is very important for the legitimacy of government. More recently, this idea of pluralism has been tied to democracy. So I have just two examples here from the European Court of Human Rights. In its well-known Handyside decision from 1976, the court found that a democratic society, as that envisaged in the European Convention of Human Rights, is one that's characterized by pluralism, tolerance, and broad-mindedness. It put it more pithily about 20 years later when it said, quite simply, there can be no democracy without pluralism. So pluralism is clearly a value which is protected by public law. But what is it? Well, in a word, it's disagreement. But disagreement about what? Well, according to the well-known American philosopher John Rawls, we disagree about religious, philosophical, and moral doctrines, or moral conceptions of the good. This has been elaborated on by New Zealand philosopher Jeremy Waldron on the right there, where among a long list of the things we disagree about, he includes what we owe to each other in the way of tolerance, forbearance, respect, cooperation, and mutual aid, among a whole host of other things. We need to only look at the current debates in these jurisdictions at the moment on assisted dying. There are currently bills being debated in both the Scottish and the UK parliaments about how to regulate this issue, which illustrates quite clearly the pluralism and disagreement that public law is concerned with. What are its causes? Why do we disagree? Well, we can think of a whole list of reasons. Here's one. Mistakes. Sometimes we're just mistaken. We don't have a correct view of the facts, so we disagree with others because we don't understand what it is we're talking about. We may disagree because of flaws of character. I might be biased or prejudiced against my interlocutor. So I'm not interested in the substance of the issue. I'm just not believing them because of who they are, playing the man, not the ball. We might disagree for self-interested reasons. I don't have a stake in the actual debate, but I realize that I can press an advantage by disagreeing with you, and we see this in politics all of the time. Now, I think these are bad reasons for public law to care about pluralism and disagreement. For one thing, some of them are soluble. Some mistakes can be corrected. But flaws of character and self-interest don't seem like the kind of virtues that we would want public law to be promoting. Rather, I think the better reasons why public law is concerned with pluralism and disagreement is this last one just separated out. Life is complex. Decision-making is hard. It's customary to quote John Rawls again and his idea of the burdens of judgment at this juncture. Those of you familiar with this literature, he sets out a list of good reasons for disagreement. I prefer my formulation. I think it distills the core idea that he's trying to get across there. Life is complex. Decision-making is hard. Now, this could be because, as Isaiah Berlin said, there are a lot of good things in the world, but unfortunately sometimes they conflict. Berlin famously argued that liberty can clash with equality in a whole host of different contexts, and this can lead to genuine political disagreement. To illustrate this more specifically, Sophocles' Antigone. She can defy King Creon and bury her brother according to traditional funerary rites. Or she can obey King Creon and leave her brother's body as carrion outside of the city walls. But she cannot do both. Similarly, Jean-Paul Sartre's student can go to the front of the war with Germany to avenge his brother's death. Or he can stay at home and look after his ailing mother. But he cannot do both. And we're all likely to disagree in good faith and for good reasons about what the correct course of action is here. And it is these reasons for disagreement that public law has in mind, I think, when it promotes pluralism as a value. So disagreement is not always suspicious. Life is complex. Decision-making is hard. Pluralism and disagreement, then, is about respecting each other and our views. It is, in its own way, a form of equality. We're all entitled to our views and equally entitled to disagree. Disagreement is here to stay. As John Rawls said, it's a permanent feature of our public culture. So how does public law protect and promote this disagreement? As I've already mentioned, public law legitimizes the exercise of public power. Pluralism is relevant here because the exercise of public power requires overcoming pluralism. Exercising public power requires making a decision, making a unity out of a diversity. We're trying to write a constitution, we disagree what we should put in it, but we need to overcome that disagreement to write our constitution. We disagree about who should govern, but we need a governor. So we need to overcome that disagreement to pick a governor. We disagree about what the correct regulatory response to assisted dying is, but we need to overcome that disagreement and make a decision. In fact, we cannot function in political society without overcoming this pluralism, making political decisions. So there are bad ways we could do this. We could be unity out of diversity. We could browbeat, which is the word I always associate with Bernard Williams for some reason, harangue people, or even worse, we could coerce them and force them to agree with us. But I think public law conceives of better ways of overcoming this disagreement by promoting its values. And this is, I think, a key function of public law in the context of the value of pluralism, legitimizing the conversion of pluralism into unity in political decision-making. How does it do this? Well, lots of ways, including according to the values that I've just outlined earlier. But two examples I think will suffice just to illustrate the point. We disagree about what we should decide. We don't know what to do, so we'll say, well, whatever the majority decides will be our decision. In this case, the pluralists or the dissenters, those who just didn't agree, can at least claim to have been heard and to have had their say in what the decision should be. This is, of course, one of the fundamental justifications of the principle of democracy. We can also legitimate this conversion of pluralism into unity by having certain entrenched fundamental rights protections, such as the freedom of expression. So even though we've created a unity from our disagreement, that pluralism can continue with the right to express disagreement with what has been decided and to disagree with the unity. So again, public law plays a crucial role in legitimating this creation of unity out of diversity. But I want to step back a bit from these specific values and principles to argue that that pluralism and disagreement is actually fundamental to the very idea of public law. In some ways, it is the key idea of public law, perhaps one that takes priority over the rest. And to support this claim, I think we can look at two particular fundamental constitutional frameworks which illustrate this point. One is the modus vivendi, and another one is public reason. Starting with modus vivendi. So modus vivendi is a constitutional framework which legitimizes the creation of unity from diversity by retaining a maximal degree of diversity. Its starting point is radical disagreement, something like Thomas Hobbes' state of nature, which many of you will be familiar with. In the state of nature, we all disagree radically, even violently. Life is, and this is what many of you will remember from Thomas Hobbes, nasty, brutish, and short. I often think when I see pictures of Thomas Hobbes that he looks a bit nasty, brutish, and short, but that's not the point. So we exit the state of nature to enter civil order. We overcome our disagreement to live in this civil order. We convert our pluralism into unity. But the political authority we create and the function of public law in the modus vivendi is about keeping a lid on violence. It's aimed at preventing a regress to the state of nature. It's not about promoting any values in particular. So in this way, in the modus vivendi, a maximal extent of disagreement is retained after the creation of political unity. We legitimize the creation of unity from pluralism by retaining maximal pluralism within that unity. The emphasis on modus vivendi is on disagreement from start to finish, from the state of nature to a maximal extent of disagreement under political authority. The second model I want to consider is our public reason models. And these legitimate the creation of unity from diversity through the use of public reason. This begins often with the fact of pluralism and adds public reason to legitimate the conversion of pluralism into unity. The unity that is created from diversity is legitimate because it is in principle justifiable or acceptable to all, even those who disagree. The most famous example of this arguably is, of course, John Rawls' overlapping consensus theories, again on the right-hand side. We legitimate unity which is created from overlaps in our diversity. So pluralism and diversity is at the heart of this model too. We start with a fact of pluralism, and the resulting unity is built upon this very diversity. So we've seen that this political pluralism is something that public law promotes. In fact, I argue that it is, in a sense, the public law value. It is fundamental to the very idea of public law. So our conclusion about the harm of populism might be something like this. Populists are anti-pluralist. Pluralism is a core feature, the core feature of the very idea of public law. So the harm in populism lies in its rejection of the very idea of public law. But is this really the problem with populism? I'm not so sure. I think populists actually love pluralism and disagreement. Remember, they are non-revolutionary. They need pluralism, democracy, and disagreement to shore up their political legitimacy. They contest elections. Populists, by and large, play the democratic game. Furthermore, their framing of society as divided between a pure people and a corrupt elite is one characterization of a pluralist society. They also have a peculiar obsession with free speech, which, as we know, is closely connected to pluralism. So here we have arch-English populist Nigel Farage saying in 2015, the idea of free speech was a reality in England when Europe was run by princes with tyrannical powers. Throughout Europe, England was known as the land of liberty. Here you had the possibility of dissent, of free thinking, independent minds and actions, and so on. Now, I won't give him a degree in history for this insight, but you can't deny that he is talking about pluralism and disagreement here. 10 years later, in an interview with that bastion of independent journalism, Fox News, he put it more pithily. Democracy is about disagreement and raising your voice. And earlier this year, the Vice President of the United States came to Europe to express his concern that free speech in Europe, he thinks, is in retreat. So I'm not sure that anti-pluralism is the problem here. Indeed, I think populism is compatible with, indeed arguably supported by, our pluralist-obsessed constitutional frameworks of public law. Populist claims seem compatible with modus vivendi, retaining maximal disagreement in politics, free speech, division, etc. But it also seems to me that populism is compatible also with public reason models. The claims of populists as a form of disagreement of the status quo seems like the kind of thing that should in principle be justifiable and acceptable to others. You too are free and equal to engage in this divisive politics. Indeed, as some have argued, such as Margaret Canova, populism is a shadow cast by democracy itself. It is part and parcel of constitutional democratic government, of public law and the dominant constitutional frameworks of modus vivendi and public reason that I've outlined. So what then is the problem with populism? We have a strong intuition that there's something wrong with what's going on, but public law seems to support it. Indeed, if public law is fundamentally about pluralism, and populism is compatible with pluralism in certain ways, maybe the problem is, dare I say it, public law. Maybe the harm in populism alerts us to the fact that making pluralism the key value of public law is not the best way to legitimate political authority, to think of the relationship between unity and diversity. And in the remainder of this lecture, I'll argue that the problem with populism starts with their framing of society. Recall, we're all fundamentally divided between a pure people and a corrupt elite. But also that this is just symptomatic of a more general problem with public law, and particularly its emphasis on disagreement. So let's start with a divisive framing, the divided society. This is not just a descriptive claim that society, our societies, our communities are actually divided between a pure people and a corrupt elite. It's also, perhaps more importantly, a moral claim. The pure people are more deserving than the corrupt elite. The corrupt elite and their supporters are less deserving. And these supporters often include minorities, immigrants, and others. As a political theorist, Chantal Mouffe and Nadia Urbinati have pointed out, this framing violates a basic ideal of equality. Not everyone is equal in society on this framing. Some are more deserving than others, to paraphrase George Orwell. So maybe the harm of populism is this attack on equality as a value. I think this is the beginning of an answer, but I think we need more. What do we mean by equality here? There is, after all, an equality of sorts in pluralism and disagreement. We're all equally entitled to our views and equally entitled to disagree. We're all equally entitled to propagate divisive views of society. Therefore, I think to better understand the harm of populism, we need a better understanding of equality. A form of equality that runs deep. The type of equality I have in mind insists that we are a political community of equals, that no one's life matters more than anyone else's. We're all genuinely in politics together, for better and for worse. And finally, and perhaps most importantly, that we realise and accept as a community that there's no getting away from this. Just like there's no getting away from disagreement. I'll come to that. If you're looking for a slogan, the type of community I have in mind here is one which takes seriously the equal respect and concern of its members. So the harm of populism, I think, this is Ronald Dworkin's work. I partly rely on this lecture, for those of you who don't know. The harm of populism is a violation of this deeper sense of equality. But as I've suggested, this harm is merely a symptom of the bigger problem of the constitutional frameworks of legitimate authority, which dominate public law thinking. Remember, with modus vivendi, we start with a radical pluralism of the state of nature, and the legitimate authority is to keep a lid on violence, but our radical disagreements persist within this political unity. Similarly, with public reason, we start from the fact of pluralism and disagreement, and move to legitimate authority through the overlapping consensus using public reason. But this unity is built on this very disagreement. And as I've suggested, these approaches are wholly compatible with and arguably support, in some ways, the divisive claims of populism and the violations of this deeper sense of equality that I have in mind. As Margaret Canova said, populism is a shadow of democracy, and there's nothing we can do about that. Equality is just collateral damage. But I don't think we need to accept this pessimistic conclusion. I think we can rethink how we understand the relationship between disagreement and legitimate authority in our constitutional frameworks. I think we can rethink the very idea of public law in a way which better preserves and promotes the sense of equality that I have in mind. How can we do this? Well, I think we need to make a Copernican turn in public law. We need to change how we understand the relationship between disagreement and legitimate authority. We need to invert the approach of these disagreement-focused constitutional frameworks of modus vivendi and public reason. So in contrast to our dominant models, which start with disagreement, a state of nature or a fact of pluralism, we should start with agreement. We should start with the idea that we are all members of a political community of equals, a community that imbues this thicker sense of equality, that we're all genuinely in this together. We need to start thinking in terms of a state of equality or a fact of equality, comparable to Hobbes' state of nature or Rawls's fact of pluralism, and make this equality a foundational assumption of how we think about public law and legitimate authority. What about disagreement? This unity still needs to be legitimised. Pluralism is, of course, still relevant here. Life is complex. Decision-making is hard. And browbeating and coercion is still off the table. So yes, disagreement is important, but we need to understand political disagreement, I think, in our deep egalitarian sense. And the way to do this, I think, is to understand our political disagreements as rival interpretations of our common values, including our deep sense of equality. This, I think, is very different from saying that we have nothing in common and that we just have to find something. We're starting in the violent state of nature, that we are so fundamentally divided and that our job is to stitch together some sort of agreement, as in the modus vivendi and public reason models. This requires that we start with agreement. And disagreement flows from our agreement in the form of divergent interpretations of common values. If I think we understand disagreement in this way, as rival interpretations of our common values, we can see, I think, disagreements as part of what holds us together. In disagreeing, we are affirming our political community and its core values, not challenging and undermining them. Disagreement is not the falling apart, the mere anarchy of Yeats's poem. Disagreement is emphatically about holding the centre on this approach. So I think thinking about disagreement in public law in this way better gets at our intuitions that populism is problematic from the viewpoint of public law. It's a violation of our fundamental shared equality. But it also, I think, highlights the fact that populism is a mere symptom. The deeper problems, I argue, are the very idea of public law and its promotion, and we might even say a fetishization of pluralism and disagreement, starting with this radical disagreement and the potential harm to equality that this engenders. So I argue for a Copernican turn, invert this approach, and start with agreement. I started by saying that public law is a norm-based, value-promoting practice. So many of you are thinking, well, where's the public law in this? It usually involves courts, judges, lawyers, legal arguments, and different types of institutional actors. So how does all this highfalutin abstraction cash out into practical advice? Well, I don't have time to give a detailed blueprint here, but there are some ideas, I think, here that are relevant to the practice of public law. First of all, we need to accept that public law is about values. Not only that, but a key value of public law is the deep equality of the members of our community, and not the pluralism and disagreement which characterise the modus vivendi and public reason approaches. Out of this, we can fashion a key principle of public law. This equality comes first. This requires that we reject the populist premise of a divided society and endorse the idea that we are all in this genuinely together. But it also, I think, requires the privileging of the facts of disagreement of modus vivendi and public reason models as a starting point for thinking about legitimate authority. We need to decenter this pluralism and disagreement in thinking about public law. We should also, as I've said, understood our disagreements as rival interpretations of common values. understand our disagreements as what brings us together, not what drives us apart, what holds the centre, not mere anarchy. And I think we can interpret the law and public law keeping these values in mind. Now, I'm lucky that one of the inspirations for this approach is, of course, Ronald Dworkin, who developed his own very sophisticated theory of legal interpretation in the form of law's integrity. And I'm looking at my daughter Nora here, and she's thinking he's not going to go on about law's integrity, is he? Don't worry, I'm almost done. I don't endorse everything that Dworkin says about law's integrity, but there's one thing he does say that I think is correct here. It's the idea that law's integrity, or in my model, equality, won't necessarily have the last word on judicial interpretation, but it should always have the first. We can also, I think, do democracy better. We need forms of democracy that follow this Copernican term that I'm arguing for in public law. An obvious example here is deliberative democracy, which is currently enjoying a moment in the sun. Now, I'm not an evangelist for deliberative democracy. There have been some successes with this idea, but there have also, of course, been some failures. And we need to be careful about how we think and launch deliberative democratic projects. But I do believe that deliberative democracy generally captures the ethos of this Copernican term that I'm arguing for. We also need to invest, I think, in public law and political education to further promote this ideal of a political community of equals to drastically improve our politics. Is this realistic? It's easy to be skeptical. We can't solve current crises with theories and models. Ideas and approaches are not a panacea. Of course they're not. They are, however, I think, the first step in a long and arduous journey that we all have to embark on. I think it's incumbent on us all as citizens, as members of our political communities, to collectively take that first step. And that first step is changing how we think about the relationship between political disagreement and legitimate authority. It involves having the courage to recognise and promote this deeper equality within our political communities, seeing each other as genuine equal members of those communities. It requires, perhaps and more challengingly, to resist the indifference, scepticism, or even fear that we might harbour in thinking about our politics today. To paraphrase another great Irish poet, Seamus Heaney, it involves embracing equality against your better judgment. Thank you for listening.